relating public adjusters in the claim process along with policyholder attorneys. All right, so think of it that way. Law and Order's intro says in the criminal justice system, you have law enforcement professionals who investigate the crimes, and then you have district attorneys who prosecute them. That's what the claim process is. You have public adjusters that investigate the loss, comply with the duties after a loss, and then you have the attorneys, if needed, that prosecute the unfair claim settlement practices. Okay? It's a relay race, but you got to comply with the insured's duties after a loss to make sure that you're setting the case up properly so it can go to a lawsuit. You heard Stephen Bush talk earlier about the duties after a loss. They are critically important. If you haven't complied with the duties after a loss, it's not ready for a lawsuit. Not only is it not ready for a lawsuit, like Stephen said, you can run into some fatal issues in the case because of the way it's been set up. So if they're alleging we don't have certain information from you, we didn't get your proof of loss, you've made misrepresentations, you're throwing things in the estimate to see what sticks, all of those can be fatal for the claim. Ultimately, as a public adjuster, you're documenting it on behalf of the insured. You need to make sure the insured is looped into that process. I can't tell you how many times I've prepared a client for a deposition, and going into the deposition, first question I ask them, have you seen a copy of the estimate from your public adjuster? You'd be surprised how often they say no. Well, defense counsel is going to ask you, would you be surprised to learn that your public adjuster is written for X? So while you're representing the insured and advocating for the insured and telling their story, you have to make sure you're keeping the insured involved with the process. If they don't know what you're writing for and why you're writing for it, and they don't understand that, then it can be detrimental to the claim. So, two separate but equally important groups. Attorneys have started inserting themselves into the claim process, and I think that's a huge mistake. As a public adjuster, you should be documenting the loss, but I see a lot of law firms out there, a lot of my competitors, where they're essentially now becoming public adjusters. They're getting involved in the very beginning of the claim. They're not giving the insurance company an opportunity to actually do what they should do, which is investigate the loss, right? Make claim determinations. See what cover damages may be there. So it's two separate but equally important groups, but I like to think of it like a relay race. In a relay race, you only have one person running at a time, right? First person's running that first lap, and you want to come in and you want to hand off that baton and you want to have a smooth transition. But in a relay race, the first runner may come in with a lot of momentum, but they're only ones that ran that first lap by themselves, right? And so you want to hand it off, and if you need an attorney, then it should be a smooth transition. So you're handing off that baton so the attorney can take it and run with it instead of the attorney being responsible for going back and complying with the duties after a loss, because that should have already been complied with before it goes to the attorney. I talked to a lot of attorneys, a lot of law firms out there where they get cases, and when the cases land on their desk, they're not ready to file suit. And it's becoming a real problem within the industry, where I think a lot of public adjusters, some of them do very good jobs documenting the loss, but some don't. Your rule book to go by is the duties after a loss. If you've complied with those and you've checked off every one of those on the list, then it's ready for the next lap in that race. But if you have not, then it's not ready to go to an attorney yet. Complaints and documentation. Unfair claim settlement practices is the law that's going to govern, in most states, what insurance companies are supposed to do or not do in regards to a claim. So I'm going to talk to you in a few minutes about the complaint process and documenting that, right? With the claim process, insurance companies have weaponized the claim process. They've made it difficult and cumbersome and almost impossible for most insureds to comply with by themselves. I have many attorneys that call me. I've had former judges that call me, state senators that have called me. They don't know how to comply with their duties after a loss, but you do. That's your role to play. As a public adjuster, you are to comply with their duties after a loss because they're weaponizing the claim process. They're making it difficult. They're making it cumbersome. They're basically making it where so many hoops you have to jump through that it's an extreme obstacle course. They're setting the insured up for failure on the claim. What they're really doing is trying to get the insured to give up. Because if they get the insured to give up, they don't owe any money on that claim. They got them to go away. Right? So don't ring the bell. Don't give up. So in SEAL training, if you go ring the bell at any given time, you can be done. You can get a hot meal, right? You can get some good, warm, comfortable clothes, and they try to push you to ring the bell. Right? Just ring the bell and it's over. Just ring the bell and say, I give up. That's what the insurance companies are trying to do. They're trying to force the insureds to ring the bell, to give up on the claim process, to come out of their pocket and go make the repairs on their own. So you have to prepare for war but hope for peace. If you set your claim file up correctly, as if it's going to litigation and going to trial, there's a better chance you're going to resolve the claim without it even needing to go to an attorney. And those claims that come to an attorney that are set up properly have a much better chance of getting resolved early in the litigation process as opposed to having to go all the way through the litigation process. So how do we do it? We want to document the claim properly. You want to gather information. That involves interviewing the insured. Find out about past losses. Have they had prior claims? I always tell clients on the phone, I want to know about every prior claim you've ever had, any prior repairs you've had. If you don't have the receipts or don't have the invoices, just give me the year, give me the information, because that's critically important. There are very few things on a claim that are fatal if they're anticipated early on in the process. If they're anticipated early on in the process, then you can usually navigate around it. You can usually deal with it. Where it becomes an issue and it could be fatal to the claim is when you're in the claim process and then it goes to litigation. And then it comes out in a deposition. Oh yeah, I did have 3 prior claims, and I did have some money, and I didn't make prior repairs. But if we would have known that ahead of time, then you could have anticipated that. As the public adjuster, before it even went to an attorney, you could have gathered that information and that documentation, right? So interview your insureds, vet the claims, ask the questions that the insurance company is going to end up asking in a deposition. There's certain things you want to demand from an insurance company. You want to demand a copy of the policy. If they're not giving you a copy of the policy, how do you know what covered damage is there? How do you know what coverages are afforded? Renee was talking earlier in the week about standardized policies. There used to be 1 of 3 or 4 different policies in Texas. Now we have hundreds and hundreds of policies. And every State Farm policy is not the same as another State Farm policy. And every Allstate policy is not the same as another Allstate policy. There's so many exclusions, so many endorsements. If you don't actually have a copy of the policy, you don't know what coverages you have. So if an insurance company is refusing to give you a copy of the policy, you need to reply back in writing to them that they were actively preventing you and the insured from complying with the duties after a loss because they're refusing to turn over the policy to you. So some things you want to do on the front end. You want to get all that file information. You want to get the underwriting file. Demand a copy of that. A lot of times they're not going to turn it over to you. Why do you think they don't want to turn the underwriting file over to you? Shows pre-loss condition, right? If you think about it, the law and order, kind of the criminal context with the intro slide, it's kind of like exculpatory evidence. They have evidence within their claim file that may completely blow out of the water the defenses they're trying to take, which is pre-existing wear and tear. Right? So demand a copy of it. I would do that with your initial letter of representation that goes out. And then when you get a denial letter, or you get a, this is pre-existing condition, this is wear and tear letter from the insurance company, I would follow that up. I now know you're taking the position that this is pre-existing or this is wear and tear. I demand a copy of the underwriting file. 99% of the time, the underwriting file helps us on this side. It does not hurt us. Does anybody know why? The underwriting file almost always helps us and doesn't hurt us, because if the roof was in poor condition, they probably wouldn't have issued the policy. Or they would have issued a letter saying we're going to non-renew you when that policy comes up. Right? Usually when I get a copy of the underwriting file, it says the roof's in good condition. The worst is usually like fair condition. Okay? It never says the roof's in poor condition because they just wouldn't have issued the policy. You need to find out if you're dealing with an RCV or an ACV policy. You need to find out if there's a roof schedule in there that has standardized depreciation that's going to be calculated in. A lot of policies now are saying that the roof converts to ACV after 5 years or 10-year period of time. A lot of them completely exclude the roof after you get past about 12 years on some of these new roof schedule endorsements that we're seeing in a lot of the policies. Conduct an investigation, right? So look at the crime scene tape. Why do they put up the crime scene tape when they're conducting an investigation at a criminal scene? Contamination, right? They want to protect and preserve the evidence that's there so they can document it. So when you're out on a loss, think of it like the crime scene tape that's up. You got to document everything you can about that loss before the crime scene tape comes down. Because you're going to have changes in condition. You may have different weather events that impact the property, right? You may have another hailstorm that comes through or another windstorm that comes through. The insurance company may say, well, that leak wasn't in the attic. If you properly document the loss, you're capturing a moment in time. You're creating a baseline that's there. So photographs are good. DocuSketch, Matterport, I think those are very effective tools because you get 3D scans, right? There's no dispute about what the condition of the property was. So you want to capture that moment in time. I always tell public adjusters, you are the eyes and ears for me and for the judge and for the jury. Right? I wasn't there during the adjustment of the claim. I'm relying upon the documentation and the evidence that you build to be able to take it and run with it. And at the end of the day, you have a lot of attorneys that want to talk about their wins and their judgments and amounts they've collected. I guarantee you know what? 99% of the time, that's because the file was really good when it came to them. Meaning that we're standing upon your shoulders as attorneys. Right? If you do your job in documenting the loss and preparing the loss to move forward, then it's a good file. As attorneys, we can make sure there's coverages there. We can make sure the policy is correctly applied. But we're really standing on your shoulders. Because if you did your job, you've run that first lap of the race, and you've handed off that baton to us, you've already built up the momentum on that file. But you're the eyes and ears for the judge and the jury and for me. I don't know what to focus in on if the public adjuster didn't do a good job doing it. So I like to say that the file is either a good file or a bad file when it comes to me. Use tools of the trade. If you're conducting an investigation, you want to use the tools of the trade that the insurance company is not going to use. I can't tell you how many times in depositions I've asked State Farm engineers or State Farm adjusters, especially after the winter storm that hit Texas and you had broken pipes all over the state, Did you show up with a moisture meter? No. So let me get this straight. You understood this was a water loss. You had a burst pipe. A $1 billion insurance company sent you out here to adjust this loss, and they did not equip you with the basic tools of the trade that you can get down at Home Depot for $20. So use drones, use moisture meters, use thermal imaging cameras. Use the tools of the trade that the insurance company does not want to use. You want to put the ball in the court of the insurance company. How do you put the ball in the court of the insurance company? By submitting the proof of loss. Anything they do before that proof of loss is submitted is really them just doing it voluntarily. So you want to make sure that you submit the proof of loss, because that's going to trigger the deadlines under state law. And in Texas, we have really good prompt payment deadlines. And a lot of states follow Texas. Texas was one of the first states that passed the model prompt payment deadlines and unfair claim settlement practices. So in a lot of different states, you have really good prompt payment laws. And the courts in New Orleans, the Fifth Circuit Court of Appeals, which oversees Texas and Louisiana when it comes to federal cases, and a lot of cases now end up in federal court, they have ruled that Texas's Prompt Payment and Claims Act is strict liability, which means it doesn't matter if they intended to violate it, it's just did they do it? Did they violate it, yes or no? So if they have 15 business days in which to accept or reject the claim, if they took 17 business days or 18 business days or 20 business days, it doesn't really matter. It's a violation. Doesn't matter if they have an excuse. Doesn't matter if they have 100 claims on their desk and they didn't get around to it. It's a violation. Strict liability laws are very key in proving things up. And with strict liability laws, you prove a violation of prompt payment, that's triggering the attorney's fee statute to come into play. You want to document everything about the loss. Right? Remember, you're the eyes and ears for me and for the judge and for the jury. You want to document every phone call you have and follow it up with an email. You want to document every site inspection with an email. Every discussion you have with the adjuster. Document that. If you document it and it's in writing and that goes into your claim file, that's building up the documentation and evidence that we have. What they're used to seeing on a lot of cases from public adjusters is that the insurance companies built a big claim file. They sent engineers out there, they sent loss consultants out there. They're papering the file. They're just building the file, report after report after report. You want to make sure that your claim file is as put together as their claim file is. Making the entries in your notes are important. Right? I can't tell you how many times I've looked at claim notes from the insurance company about maybe what occurred during an inspection or what the insured said. And then I go to the public adjuster's notes and look and see if they made an entry on that same thing. Right? Because I want to get the point of view of what actually happened there. Sometimes the insurance company says, the insured denied access to the property. And I flip over and look at the public adjuster's notes, and I say, oh, well, there's a lot more to this story, right? The insured did not deny access. The insured just said it was rainy that day, and maybe it wasn't a proper day to come inside because the adjuster had wet and muddy boots on at the time. So it's important that you're creating that narrative. When they're writing entries in their claim notes, their claim journal, they're putting a narrative out there. They're putting out false information. So it's incumbent upon you to capture and write down what actually happened. We need your version of the events. How long was the adjuster on site? Were they there and able to actually do a proper investigation? Mark did a lot of school district cases with me. We would find out when we get copies of their, the native photographs with the timestamp on it. Some of these school districts, they were going out and they were inspecting it like 30 minutes. Timestamp 9:01 a.m., last photograph 9:37. How'd you inspect a high school in 36 minutes? Right? So document when they start their investigation. and when they conclude their investigation. Document if they're bringing out Ladder Now or Ladder Assist or some other company to assist them. There's nothing wrong or improper about bringing out Ladder Now or Ladder Assist, but you have to see what they're being tasked to do. If they're the only one conducting the investigation, and a licensed adjuster is not going behind them and verifying that information, then that could be unfair claim settlement practices. But I can't prove that if you don't have the documentation in your file. So if only the Ladder Assist company got on the roof and the adjuster never got on the roof, that needs to be written down. That needs to be documented. So I want to talk about complaints for a minute. Filing complaints, I believe, is critically important to the process. Duties after a loss have to be complied with before you can move forward with it, right? But what mindset do you want to have when you're filing a complaint? I have the picture up of the cop writing out a ticket. That's how I like to think of it, right? Sticking with the law and order theme here. It's like the police officer that's writing a ticket. What's the police officer doing when they're writing out a ticket? They're saying, here's the law. The speed limit's 55 miles an hour. Here's what you're doing. You're doing 67. Are they finding you guilty of that at the time? No. They're just documenting they believe you violated the law and here's how they believe you violated it. And then ultimately go tell it to a judge or jury. That's what you're doing when you're filing complaints. You're saying, here's what the unfair claim settlement practices says. Here's what your actions are actually doing. Here's why I think you violated this. And you file that complaint. Now, the Department of Insurance is not going to be your friend. They're not going to come in and adjudicate the facts and say, you're right and Allstate's wrong. But what they do is capture that information. They basically act like a clearinghouse. But capturing that information is important. Because when they capture that information, it gets logged into the system. And Renee told you on Wednesday about all the laws they're trying to pass and change. Guess what the insurance companies go tell the legislatures when they want to change the law? We're doing great. We got no complaints over here. Right? Look at this complaint box. It's empty. File the complaints because that logs it into the system. Right? And there's things under the insurance code where the insurance company has to keep internal complaints and self-report that. But I don't trust insurance companies to self-report. Right? So I like filing the complaints with the Department of Insurance so it gets tagged, it gets documented, it gets categorized. It's like the police officer writing out the ticket and then sending it into the court system. Ultimately, the judge and jury will determine whether it's unfair claim settlement practices. So you want to stick to the facts, just the facts, when you're documenting your complaints. But if you don't write that down, there is no time machine. I can't go back in time and determine what they did or what they didn't do. Right? I can have all the estimates and all the reports that the insurance company issued in front of me, and I can have your estimates and your photographs in front of me, and I could know very little about the file. Because that doesn't tell the whole story, right? You need to have the narrative. What occurred? When did it occur? What's the timeline look like? What were you telling them? What were they telling you back? Capturing that information is critically important to the process. So document violations of the law. File the complaints. Right? When I'm drafting a suit, usually I go in and look at the complaints that were filed. Those are issues I'm going to key off on in drafting the petition and getting it filed. Now, you want to have some meat on the bone when it comes to the alleged violations. If you said somebody's misrepresenting things, they're misrepresenting the policy, I want to see how they're misrepresenting the policy. What did they say? Who said it? Right? So, John Smith, adjuster at Allstate, stated on May 1st, 2022, that Allstate does not pay for overhead and profit unless it's a complex loss. You have that in quotes because that's what they said. then when opposing counsel calls up and says, what are all these misrepresentations? The documentation's there. It's not throwing things at the wall to see what sticks. I can say, I can tell you exactly about the misrepresentation. It was done on this date by this adjuster, and here's what he said. You know what opposing counsel usually does when I says that? They say, oh, okay. We're not going to file a motion to dismiss on that then. You have facts. It's not just an empty allegation without any facts backing it up. You want it to be a relay race. Document your file, work it up, comply with the duties after a loss, so that if it needs to go to an attorney, you can have that smooth transition. You can hand off that baton. You don't want to come in where you're losing momentum on the file. When does it need to go to an attorney? When you lose momentum. When you start losing momentum on the file, that should be when you should start looking at wrapping the process up. Doesn't mean it needs to immediately go to an attorney right then and there. But maybe you need to start thinking, okay, 10 days from now, 20 days from now, I'm probably need to wrap this up and get this ready to go over to an attorney, if it needs an attorney. How often they send the engineer out, and after the engineer comes out, they open up coverage and pay more money? Never, right? I've had it happen once, literally once. And I think it was that engineer's first day on the job, and he probably never got another assignment after that, right? So if they're sending in the engineer, doesn't mean he needs to go to an attorney right then, but that needs to be a triggering point to you. I think they're papering the file on their side. I anticipate there's going to be a denial coming down the road. So I want to make sure and dot all my I's, cross all my T's, start getting this wrapped up and getting ready to go. So thank you all for coming out today. I wish the first slide would have played because it's a really cool slide. So the law and order slide, I dubbed over it with my voice talking about public adjusters and policyholder attorneys. So I'll have to find that slide. I guess I brought the wrong last slide today. But I'll get that posted and sent out to you because I think it's a really cool thing. Thank you all for coming to the conference. We've got a couple more great speakers. But before I get off stage, I want to say we have Memorial Day coming up. Please go out and remember the military veterans, those who sacrificed, made the ultimate sacrifice by giving their life in defense of our country. But also, please go out this weekend and really take the time to thank those that help support you and be able to go out and fight for the insured. I'm honored to have my family here with me today, my wife Natalie and son Slade and daughter Nessa. I see Cal and Melanie have their son Jackson with them. It's the people that support us, your spouse, your children, that have to put up with the difficulty of you working storms, of your schedules sometimes. Sometimes the calls on nights and weekends when you're trying to help the insured and protect the insured. So really take this weekend to remember the sacrifice of the military individuals that gave the ultimate sacrifice and died for our freedoms, but also take an opportunity to thank those in your lives that help support you